And welcome everybody. Today we're looking at housing in a hostile environment. This is part of the Stand Up Speak Out series. You've all signed on, so presumably you've read the publicity about it. Essentially, this is about a whole range of different organisations joining in order to try and encourage particularly people offering services, although also people advocating for people who need services. To challenge, if you like, and to think about how the hostile environment works and the role that service provision plays in it and what they can do about it. So this session is one about housing, and it's quite sort of focused on particularly local authority housing, although we'll also be talking about the eligibility checks you get in private rented housing. And it's kind of based on training I do anyway for local authorities, but also for lawyers, social workers, that kind of thing, and also for voluntary and community organisations. And if you are involved in community organisations in particular, please don't hesitate to come back to me and say, could you do a session like this for us? I'm very happy if I can fit it in to do the odd sort of hour or two with community organisations on understanding how housing eligibility works. And really, this is the main focus of what we're going to be doing today, is understanding that. I'm doing this on behalf of an organisation of which I'm a director. It's a community interest company, in other words, a not-for-profit sort of enterprise, if you like, that basically offers consultancy on making migration work for the benefit of all of the communities involved. We work a lot with cities, rather less in the UK than we do a lot of work with European cities. And we also do a lot of work with NGOs in particular. We're evaluating something for the GLA, and we're doing some work with various other NGOs you've probably heard of and so on, in terms of helping them organise services or evaluate or things like that. Just a little puff for what we do. There we go. That's what we do. This is a puff because we're doing it pro bono. A lot of the work we do is pro bono. But essentially this is who we are and what we do, so that when you get the slides, which you should get after today, I hope, you can look them up and pass them on to colleagues and say, here's some interesting people. We're the only not-for-profit sort of company who does consultancy in this field. And we also have an associated trust, the Migration Work Trust, that does a lot of work around around supporting particularly community-based organisations in the UK. Sort of checking. I'm assuming that all the things in the chat are simply people telling everybody who they are, because I can't see that so easily when I've got the screen up and so on.
Yes, it is you.
Okay, thanks. So, issue is, what are we looking at here? And really, thanks. So, issue is, what are we looking at here? And really, we're looking at how the hostile environment affects housing. And we're looking at two areas, one of which, well, three areas technically, really. The first is that there are eligibility rules for accessing council housing registers, which is what waiting lists are called, or have been called for some time. And that also covers the situations where local authorities send people to get housed by housing associations, or where housing associations and trusts run joint waiting lists with local authorities. I'm specifically looking at the rules in England in this session, but these rules there are very similar rules applying in Scotland, Wales and Northern Ireland. They're not identical for all sorts of technical reasons. You know, housing is a devolved area, immigration isn't, but they're very similar indeed. And anybody who wants to can come back to me and I will tell you about the rules in the other nations if you want. Essentially the same eligibility rules with some very minor tweaks are there also for people who want to get help from the council if they're homeless. And in order to get any sort of physical help, if you like, in terms of putting a roof over your head as an emergency or longer term if you're homeless, then there are eligibility rules for that. And I'll be explaining those as part of what we're doing today. And then there's also the private rented sector. So if you want to rent privately, you will need to pass the tests in the right to rent legislation, which I will also come on to. And that covers all new tenancies in the private rented sector in terms of getting into those tenancies. And it also includes housing associations where they're not offering housing via a local authority waiting list or a joint waiting list. So if you go to a housing association, for example, who in terms of applying to them directly, as you can in many areas, not so much in London or other areas of extreme housing stress, then what will happen is that you will find yourself, essentially, you should be finding yourself facing the same test as the private sector tenant would. And those rules were also amended in 2016. And there are some provisions within the right to rent that covers all tenancies, not just the ones that have been started since 2016. They could technically, cover somebody who moved in 10, 20, 30 years ago into a private rented sector flat or home. And lastly, just to note, this is very much about housing. There are other sessions in Stand Up, Speak Out that look at social services and the Care Act and the options for some families with children and so on, who may be able to get help under the Children Act. And of course, there's also options if you're in the asylum system to get accommodation and support from the Home Office. But people who are excluded by the eligibility rules who then need to go to either social services or the Home Office will need to be aware that the Home Office will, in almost all cases, it will make the Home Office aware of their presence and where they are and what their situation is. So although there is, if you like, a safety net there, it's a safety net with the provision that the Home Office will be informed about your accessing it. So just to kind of move along a bit. In terms of housing eligibility, we have had rules about this since 1996. Okay, so the hostile environment was only called the hostile environment, I think, in the earlier years of this century. But actually, we've had a hostile environment in housing for a long time. It was introduced at roughly the same time with some different legislation as a whole range of benefit rules about eligibility and so on. And generally, the rule is that the eligibility rules restrict eligibility of people to housing, and the general rule is that the rules cover anybody who is here who needs leave to remain. In other words, people who are subject to immigration control, and restrict their access to housing to only those who are in what are called eligible classes. And excuse me. And then for other people, for British citizens, Irish citizens, and some European citizens who are still covered by rules relating to Brexit, then there will also be restrictions on in terms of the right to reside for the Europeans and about people being habitually resident. So a newly arrived British citizen will not necessarily have access to housing, depending on whether or not they are habitually resident when they arrive. Okay, but this only covers new local authority tenancies and nominations. So anything that's going through the waiting list, or as it's known, the housing register, and it covers all applications for help as homeless. Just notice it's about new tenancies. So if you've got somebody who's an existing council tenant, then if they need to move, for example, to transfer the tenancy, to move somewhere else, or if the tenancy is moved between them, say, for example, and their now ex-partner, or their child might want to inherit the tenancy when they die or whatever, those don't count as new tenancies, and there are no eligibility rules about those. There may be problems with benefits if the person coming in is not eligible, but that's another issue. What this doesn't cover is getting housing advice, okay? And there are two areas where the local authority has a duty to provide housing advice. And the first of those is that anybody threatened with homelessness, in other words, anybody who's going to become homeless within the next 56 days, has an entitlement to get advice from the local authority or from somebody that the local authority is facilitating, although that does include things like telling you the phone number for shelter. Then basically the local authority has a duty to ensure that there is advice available free of charge to anyone in the area who is threatened with homelessness or is in extreme housing need. Okay, it's not a very enforceable duty, unfortunately, but it is there. And it is important to notice that if people turn up to the local authority, they need to be able to get that advice. It needs to be accessible to them. And that means actually really, practically accessible, available in the relevant languages, available to people who might have difficulty managing written information, available to people who might have difficulty understanding it or whatever. And there's also further duties to provide services to private tenants. And those are generally duties to inspect potentially unfit properties and make orders where relevant in order to ensure they're fit for human habitation, and also to protect tenants against illegal eviction and harassment. So if the landlord is threatening to evict when without getting the necessary court orders or anything like that, the local authority does have to advise and assist tenants, private tenants in that situation, regardless of their immigration status and whether or not they have, they passed the right to rent tests and things like that. So the way allocations work, just to note sort of quickly, is it's actually a two-stage process. As a two-stage process with a huge difference in the numbers of people at each stage. So stage one is that local authorities who have housing must maintain and register a waiting list, and they must make sure, insofar as they can, that only eligible people go onto it. Mostly that's now done online. You go to the council website and you fill in a form, and at some point it'll start asking you questions about your immigration status and how long you've been here and that sort of thing. And it might then say, sorry, you're not eligible. Okay. Of course, lots of people go on the waiting list. A very small proportion, usually in single percentage figures, of people on the waiting list actually get housing. And it's at that point, when housing is allocated, that councils tend to do more kind of specific tests, in particular asking for documentary proof. If you've got a good council, they should tell you that that they'll be wanting that documentary proof, and to when you go onto the register, and to encourage you to make sure you've got the pieces of paper or whatever, electronic proofs and so on that you need. And that basically covers all new council tenancies and all new council nominations to housing associations. But you don't need to be eligible, as I said, if you simply want to swap with somebody else, or you want to move to a more suitable place within the council system or in another council, or if you want to, if you want to die and pass on, if you want to pass on your tenancy to somebody who could succeed because they're a family member. And the second set of council processes that we're looking at is essentially that local authorities have a duty towards people who are homeless or threatened with homelessness. Legal definition of being threatened is within 56 days. Okay, and they have a duty to ensure that advice is available to all those who are threatened with homelessness, irrespective of whether they're eligible for any further services. But it's turned out to be a duty it's quite difficult to enforce. So if you go to the council and they say, no, we can't help you, you're not eligible, and all you need, but you didn't get your advice duty, it might be difficult to then take a legal case to enforce that. But it is important to ask councils and to say, what are you doing about this duty, and to keep them on their toes about making sure that advice is available to everybody. And of course, that advice can cover all sorts of services that might be available to non-eligible people, like, housing providers who don't have the same strict eligibility rules, like the services from social services to households who can't access housing in other ways, and so on. For anybody who passes the eligibility test, which is the first test, then the local authority has a range of duties. They have to help them, assist them. They have to assess their homelessness. In other words, find out what's going on, why they're becoming homeless, and so on. They have to, if they can, prevent it. And then if they pass other tests about being in priority need, not being intentionally homeless, those sorts of things, which we're not going to deal with in any detail today, but people can ask about and so on, then they also have a duty to relieve homelessness. Relieve homelessness means put a roof over your head, at least on an emergency basis, on an interim basis, on a temporary basis, and then to secure that housing becomes available to you longer term. That may not be a council home, of course. It might be that they find a private sector landlord to take you on, and so on. Okay. When they are assessing the first thing they assess is eligibility. In other words, if you're not eligible, it doesn't matter how homeless you are, it doesn't matter how many children you have, it doesn't matter how blameless you are, it doesn't matter how long you've lived in the area, you simply won't get any further services. The homelessness process is a kind of a linear one. That, you have to tick each box as you go. So first you have to be eligible. Then the question is whether you're legally homeless or not. Whether there's no longer somewhere that you can continue to occupy, that it's reasonable for you to continue to occupy. Then there's a test of whether you're in priority need, which is about your household or you and your household composition. So you're in priority need if there is a child or a pregnant woman in the household or a vulnerable person. Then you have to check on whether the person is intentional. Sorry, once you pass those tests, then you're kind of in with a decent chance at least of getting emergency and interim accommodation. Then if you are intentionally homeless because you did or failed to do something as a result of which you became homeless, then you may only get temporary accommodation. But if you pass that test, then the next one is that local authority looks and say, do you have a connection with us? Because if you do, we'll then have a long-term duty towards you. If not, then we may refer you on to another local authority. But if, like many of the people coming out of asylum hotels at the moment, you actually have no local connection with anywhere, some of them do, some of them don't, it's complicated, I won't get into it, then basically the local authority where you applied has the duty towards you. So that's the homelessness process. So in terms of passing that key eligibility test, what happens? Okay, people are basically divided into two groups of people. There's two different sets of regulations that tell local authorities or applicants whether they're eligible or not. The first group of people, those subject to immigration control, that is people who need permission to enter or remain in the UK. Anybody who's not a British citizen, Irish citizens are sort of in there by default effectively, or anybody who is not covered by the rather complex rules around the withdrawal agreement from the EU. So those are the people who are not subject to immigration control. They don't need permission. Okay. Other people are subject to immigration control, so that's like everybody else. It's people who've got indefinite leave to remain and have had it for 40 years. It's people who've got limited leave to remain. It's it's people who just got their refugee status. All of those are people who are subject to immigration control. And the way that works is that if you're subject to immigration control, you are only eligible if you are in an eligible class. And as you could see, there are quite a lot of them because the classes go from A through to R, A, B, C, D, etc. Okay, just to make things a little bit more fun, for some reason, the relevant ministry, which is now DLUP, local government and housing and so on, has basically given slightly different class letters to the eligibility classes for people who are homeless and the eligibility classes for people who are looking for an allocation through the waiting list, but they are essentially the same people. They just have slight, one letter difference in some cases. Okay, so if you're in an eligible class, you're in. Sometimes you have to pass the habitual residence test as well. If you're not in an eligible class, then you're out. But for the other group of people who are not subject to immigration control, UK and Irish citizens have to pass the habitual residence test unless they are exempted from it. And the general rules about exemption from the habitual residence test, there's two groups of people who are exempted. One is always exempted. It's people who have been removed by force of law from another country. So it's people who've been deported or removed from somewhere else, basically. And that's because there's a risk they turn up and be completely destitute. These will be British citizens in almost all cases. Or the other group of people who are exempted is that periodically, because there has been some sort of evacuation or some sort of an event that has meant that people are likely to turn up rather suddenly, then they will be exempted from the habitual residence test. So at the moment, for example, Sudanese are still exempted from habitual residence test because of events in Sudan last year. and generally people who have had to leave Palestine, Israel, and the surrounding countries, Lebanon and so on, and Syria. I mean, as a result of the events in October last year and subsequent events, this is how the regulations are written, then they will also be exempted from the habitual residence test. Okay. Then you've got this other group of people that are put into this group of people who are not subject to immigration control. Now, those of you that know immigration will know that actually they are, because what happens is they've got an immigration status. It's pre-settled status given via the withdrawal agreement. So people who've applied for settled status and been told you haven't been proved you've been here long enough, so you're on pre-settled status. And it's also what are called relevant persons, people who've applied for settled status. The Home Office has received the application, they've given them a certificate to say they've received it, but they haven't yet made a decision on whether they're pre-settled or settled or nothing. Okay, so all of those people, a dwindling group of people, but still a significant one, as far as housing eligibility are concerned, they're pretending that housing eligibility will pretend that those people are not subject to immigration control in order to apply the same rules as we used to apply to EU citizens to them. In other words, that they have to have what's called a qualifying right to reside in order to be eligible. Now, that's a very complicated legal area. Generally, qualifying rights to reside are because you're working or were working and are still covered by those rules, or you're self-employed or were self-employed, still covered by the rules, or you're a family member of one of the above, or you're a student, or you're a self-employed person. They're all quite complicated sets of rules, but I do find that local authorities quite often misreading, well, actually, no, reading quite accurately some very misleading publicity from central government sometimes, say, oh, well, if you've got pre-settled status, you're not entitled to anything. And that's absolutely not true. If you've got pre-settled status, then you are covered by the withdrawal agreement. And that means that if you have a qualifying right to reside, then you will generally be eligible for housing. You may also have to pass the habitual residence test. Now, that is, a huge amount of information, if you like, to take in and so on. And there's a lot going on there. So, and there's no chance in an hour of going through all of those and telling you who the eligible classes are or how the qualifying right to reside rules work and all the sort of wrinkles in it and so on. I've got some useful stuff coming up about things that are useful to know, common things that people ask me about or cases that people ask me about that seem to be in trouble. But I really want to show you two things. One is, and I'm not sure if I can do this on a shared screen, it's the Housing Rights Info website, and I'm about to try and go into that and check. I'm just waving this at you, really. I co-edit this website with the brilliant benefits person from the Institute of Housing, Sam Lister, who many of you may have come across because he co-writes textbooks on benefits and housing and so on. And it's been around for a long time, but we do update it frequently and regularly, and certainly whenever anything happens that needs to go in there. And as you can see, there are basically two sections to the website. One is aimed at new arrivals, and the brief for that is, we want to give you information in plain English about your housing rights and options if you are a migrant to the UK. And the other is for housing advisors, and the aim of that is to give people like yourselves who may be advising people about housing options and rights information that they may need in order to advise new arrivals. So just clicking through to new arrivals, it's you can see that across the top here, what you've got is a load of categories. Now, we reckon they cover sort of 99% of migrants. And if you've got the other 1%, you probably need to make a note of my email address at the end and come back to me on that. But basically, it covers asylum seekers, refugees, people who've been trafficked, people with indefinite leave, limited leave, Europeans, lots of Europeans, British and Irish citizens, people fleeing domestic abuse because there are specific rules around access to housing and so on in relation to them. People with social care needs, which generally covers people who maybe are not eligible for housing, but may be able to get housing from social services. And people who are destitute, which is about providing housing advice to people who may be undocumented or be uncertain about their immigration status. So looking at this, for example, let's say if you're a person with indefinite leave, you will get this page if you come to it as the new arrivals page, which will tell you about the documents you might be asked for, an immigration status or a letter from the Home Office or whatever, your rights to housing and benefits and how that all works. You know, you have to be habitually resident, for example, and also that you can go to housing associations or a private or a private landlord. Excuse me for whizzing around a bit, and sort of close your eyes when I do that if you don't mind. Down the side, what you find is a load of extra information explaining all sorts of things, how housing works, what eligibility is, how you can apply to the council, how you can apply as homeless, finding a private rented home from a private landlord, and also some benefits information, and crucially, challenging discrimination in housing, how you can do that. So that's that side of things, okay? Now, if you come over to the other side, advising people with indefinite leave to remain, what you'll see there is some bits and pieces. You know, there's sort of stuff about people serving in the armed forces, because there are specific ways in which they get particular types of immigration status and so on. What happens when family members come to join people with indefinite leave to remain? What happens to people who are subject to an undertaking? This is people who are dependent relatives with care needs who've been given a specific visa to come in on that basis, and where people have signed an undertaking on their behalf. And by the way, what happens with them is they're given indefinite leave to remain when they arrive. There are tiny numbers. You're not going to meet many of them, ever, really, because the rules are so restrictive. But generally, if they do turn up, they'll be given indefinite leave to remain. But for the first 5 years after that, what will happen is that they will not be eligible for housing or for means tested benefits. So if they do then need rehousing or whatever, they're going to have to go to social services, and social services will then go back to the family members who brought them and charge them back to the accommodation that's being provided. Unless, of course, they're all dead, in which case there are special rules. Okay, and then there's any particular problems. I can't remember what those are here. Issues about claims for universal credit by couple. Rules can vary because there are particular issues about how the localism sets rules and things like that. That's the website. And also, sorry, just coming back down here, there's also a load of extra papers, web pages or whatever here, explaining key immigration terms, the law. And if you want to look up the regulations, if you go to this one, the law on housing eligibility, you'll always find an up-to-date version of the regulations. You need to be aware that basically the regulations just keep getting amended, sometimes 2 or 3 times a year. And so trying to find your way through the relevant statutory instruments to pick it up is impossible. So we've done it so that you've got the current as amended regulations or whatever. And also about the legal differences between housing associations and local authorities, advising migrants about the private rented sector, and again, discrimination, which we think is a key area, with very, very few, almost infinitesimal housing discrimination cases in terms of race. And so, quite an important area. There is, by the way, a very interesting new but expensive legal textbook on challenging discrimination in housing, which came out last week. And there's an article due in Legal Action, might even be this month or next month, on challenging disability discrimination in particular. But housing and race discrimination is a very, very under challenged area. We know it happens a lot, but we're not actually getting people challenging it much because it's so difficult to do. Okay, I'm sort of coming back now and about to share screen and go back into that. I just want to check the chat and see. Okay, is there anything?
There is a question actually.
Oh, good.
Revoke, do you want to unmute yourself?
Hi, thanks, Luke. Thanks, Sue. Just something you were saying about the habitual residence test not applying if people were from Sudan or Palestine or other places that they've been like rapidly evacuated from. Could you just say a bit more about that? Because we know lots of young people from Sudan who have the council's refused a duty to house them, and I'm just wondering if that means that we could challenge it on that basis. Thank you.
That's a really good question. Thanks. The regulations on Sudan were introduced last year, and essentially they come into two different sort of sets of regulations. As I said, always people subject and people not subject to immigration control. So if you think about the very chaotic evacuation that happened from Sudan last year, what happened was that a whole bunch of people were basically stuffed onto planes and sent in, mostly to Birmingham Airport, and then sort of moved around the country to go and stay, very often with family, friends, or anybody they could, some of whom then applied to local authorities for housing. Now, the people who were put onto the planes were generally British nationals and their family members. And so, I mean, some of those British nationals may never have lived in Britain. They might, they might have inherited citizenship, if you like, from parents or whatever, or hadn't lived recently in the UK. So those people are specifically, if you like, exempted from the habitual residence test. The other people who are evacuated who are not British nationals will almost all of them be people who are subject to immigration control. And there's a specific class of people subject to immigration control, and I can't remember the number, but it's towards the letter, but it's towards the end of the alphabet. It'll be P, Q, or R or something like that, who are eligible because they've been evacuated specifically from Sudan and given the leave that most people were given when they entered. And my understanding, talking to Sudanese groups, is, I mean, it was kind of chaotic. That basically a lot of people were given 3 or 6 months limited leave to remain with recourse to public funds at that point, and then told that they had to go on and then apply for any other kind of status. So normally they should be able to, then when they apply, they should be able to keep their current immigration status while they're waiting for any application to be made. So I don't know who the people are that you're seeing turned away, but just being Sudanese isn't enough. It's that you have to have left as a result of what happened last year, and generally to have either been a British national who left, whether you were evacuated or not. I mean, a lot of people were missed out and had to make their way through wherever, to get here, or you were given leave as a result of that evacuation process. Does that make sense?
So I guess I'm thinking about young people who've been given refugee status who have come overland and by small boats, so they just wouldn't be.
They'd be eligible anyway, because people with refugee status are eligible.
But I guess the council have turned a lot of people away and not accepted duty to house people.
Okay, that shouldn't be on eligibility grounds, and I'd love to see letters and so on saying that. It might be because they say they're not priority need. I mean, there is that issue. There's a huge issue about priority need and young migrants and refugees, which is the issue. I mean, it's a word I don't like using, but it explains it very well, of adultification, which is that young people who've made their way here, once they turn 18 and can apply for housing or whatever, very often, assuming they're eligible, then get told, oh, well, you're pretty resilient, so you're not in priority need, you're not vulnerable because you've made your way here. So obviously you can manage. It's not like you can't get, can't cope with life or whatever. Whereas in fact, very often, as we know, those are young people who have been through pretty traumatic experiences and really should be regarded as being vulnerable and in priority need. And that tends to be the issue, I think. But you know what? My email's on the last slide, or the last but one. Please email me about those, and we can unpick them a bit and take a look and see what other options there might be and so on. And sort of think about putting together challenges. Because I think that adultification of young migrants is something that happens a lot, and we need to start challenging it. But that's about vulnerability rather than about eligibility. Okay. Oh, Selma, you've got your hand up, I've just noticed.
Hi, yeah, I've just put my hand up. I had 2 questions, please. Just off of the last question, I wanted to ask about maybe if you could speak a little bit more to the priority needs, and because I seem to think that it seems quite strict, but then there's certain situations where young people can't advocate for themselves because they don't have the language to do so, and councils aren't giving them the support in looking for housing. They might give them like a website to look at private housing, but they obviously don't have financial means to pay for
Yeah.
it, and they also don't know how to converse with people because they don't have the language to do so.
Yeah.
So that's one question. And another question that's quite separate I wanted to ask was, you spoke a little bit about, discrimination based on race when applying for housing, and I was wondering if there are any laws in terms of trans people, just like safeguarding them within like councils or giving them appropriate housing where they're not, made more vulnerable.
Okay. I think I'm probably not that qualified to answer the second question, but I'll take a punt at it and see where we go. The issue about priority need is a slightly complex one. So essentially, the deal is you pass the eligibility tests. You have to get through those first. Then you actually are, regarded as legally being homeless. And then the council says, well, hang on a minute, are you in priority need? The definition of being in priority need is that you are a household that includes a child or a pregnant woman, or you're a vulnerable person. And a vulnerable person is someone who is less able to get or keep housing than the average, the man in the street or whatever. And there's been a lot of case law around vulnerability and how that works. I mean, one thing that everybody should notice is that the rash of hotel evictions that we had actually created a whole bunch of people who are vulnerable simply because they couldn't access housing, because they didn't have their documents, which would enable them to find housing, either because they were, even in the private rented sector, because they didn't have the documents that landlords wanted and so on. So, I mean, there's a whole load of stuff on the website, by the way, about that gives you the kind of legal arguments that you can use in the letters and things like that. But essentially, that made people vulnerable because they were being chucked out of the accommodation they had without the documentation that they needed or the access to benefits that they needed in order to be able to just go out and rent somewhere. So when you've got, say, a young person who finds themselves in a situation where they need to find their own housing, you need to be able to argue that they are vulnerable because they are, quote, less able to get or keep housing than the average. And that can be a whole range of factors. I mean, when I used to run an independent housing aid centre, I used to say, you know what, if you can get to 3 sides of A4 on what makes this person vulnerable, I reckon the council will sort of accept you anyway. But it's medical stuff, it's emotional stuff, it's mental health stuff, of course, which is within the medical, but it's also added vulnerabilities such as language and so on. So just not being able to speak English by itself is not going to make you vulnerable. But if you have a range of different problems, it's not, oh, vulnerability is this or this or this or this. It is this person is or is not vulnerable because of all of the different things that they've got. So you can kind of add it on to the range of problems that they've got in terms of accessing housing. It's very much about being able to get or keep housing. So if you've got, sort of medical diagnoses that show that this person may have more problems in being homeless or whatever, if you've got evidence from other people about their inability to manage, then that should also add to it. I would say it's always worth challenging on vulnerability. The other problem is that local authorities tend to look at it through a medical lens, and many local authorities subscribe to these private companies that offer to do their medical assessments for them. And speaking frankly, very often on the basis that they're more likely to say you're not vulnerable than that you are. These are the same people who assess people for fitness for deportation very often, for example. So it's not difficult to challenge those assessments because these doctors who write the reports have never seen the person, have not interacted with them. They've just been sent some information and write it up. And most courts will look at that. And if you've got contrary evidence from people who know them and work with that person, then you can challenge that quite well. But there's quite a bit of stuff around vulnerability and hotel evictions, which you may want to look at. On there. On trans young people, I mean, as you've heard what I've said about vulnerability, that would be a contributing factor. The transphobia that young people face and the difficulties they've had getting so far and the trauma they may have suffered in coming out and so on are all factors that may make them vulnerable. And you just sort of have to kind of do the work and argue the case, I think, and then challenge if it's refused and get legal advice and go to court on it if you need to. because eventually you'll create the case law that you need that will say what weight those different issues should be given in vulnerability decisions. I've got, is it Sheree with a hand up? I don't know if Brian, if you've got anybody else that I can't see. Sheree?
Yeah, is this
Hi.
true? You're still muted, Sheree.
Can you hear me? Can you hear me now?
I can hear you now, great.
Oh, okay. Sorry for So my question is, the refugees and asylum seekers, after getting a status, because getting your status meaning you get protection, right? And then getting a protection, and then council will qualify you as more priority need. That means they cannot house you, right? So that means you're gonna end up being homeless, but you have a protection. And being a homeless doesn't mean you are not protected, because imagine in this code you are homeless. It's not protection. It's not protection. Because also I have experience of being in Germany, Holland, and France. The moment you got a protection, they have a system that directs you straight away to your housing. Yeah. And if France and Netherlands, Germany can do that, I think Britain can do better than that. And why they make the system like that to lead people to homelessness after accepted them their refugee status, and how this issue would could be resolved.
Okay, well, if I stray away from the legal for the moment, I would say that essentially, I mean, there have been attempts to set up proper policies to enable people to, you know, sort of access housing successfully once their refugee status is sorted out. Some local authorities still try. I mean, I know some of the local authorities in London have, you know, got quite active in, you know, people are being thrown out of the hotels and so on, and getting them into being able to access deposit schemes and things like that to get them into private rented housing. But you're absolutely right. It's a nonsense. It's not, you know, it's essentially saying, well, refugees, you know, fall through gaps in the law. But those are gaps that also apply to quite a lot of other people. I mean, young people leaving home, you know, will find themselves in the same situation, essentially, of being unable to access things, with maybe more advantages because they've got contacts and the knowledge they've got from living here, etc. But yeah, I agree. I mean, I can't disagree with that. It's what the hostile environment is about. I mean, it's why the hostile environment was set up in order to discourage a range of migrants from using services and so on, in an attempt to, you know, to make some people effectively deport themselves. And it caught an awful lot of people up who had rights. Refugees are one of those groups of people. The migrants who arrived, you know, in the Windrush generation are another of those groups of people. And, you know, to a certain extent, it's the job of people like yourselves who are advocating to try and make sure that the people you're representing or advocating for don't fall through the holes. All I can say is refugees are eligible, but they won't necessarily be in priority need because they won't necessarily be able to, if you like, show that they are vulnerable. And they would have to go in there and make the case that they are vulnerable, and that just being a refugee doesn't make you vulnerable. In Scotland, I think, I'd have to check that it's still in there, the code of guidance that local authorities have to guide the way they deal with homeless applications says you should consider whether being a refugee makes somebody vulnerable, but it doesn't say to local authorities you have to find them that they are vulnerable and therefore are in priority need. It says you should just consider it. And we could obviously push for more. I mean, there's mention of possible vulnerability in other contexts as well. But like I said, vulnerability is not one thing. You can't just sort of tick one box and say, okay, this person is vulnerable. It's the personal situation of the person there. So it's their health problems, it's their lived experience, it's their access, you know, their actual practical access to housing that makes them vulnerable or not vulnerable. Somebody in the chat said something. I can see the same. Okay, yes, this is all about people who are survivors of modern slavery or torture who've been made deemed non-priority and made homeless. And it's absolutely that. It's about providing a range of evidence of those situations and so on. I mean, you know, people in those situations as survivors of torture or modern slavery probably have more to say about being vulnerable than others, but equally there's no guarantee that they will be found to be vulnerable. Sherif, are you coming back on that, or because I wouldn't mind getting on, but yeah. Sherif?
Yeah. So if you're not found to be priority need, however, you are still in need of housing, right?
Yes.
So then what are they doing instead of making you homeless?
What they should be doing is offering you advice, but advice in a situation where we have a shortage of affordable, accessible housing won't necessarily get you into housing. But they should be able to advise you about how to access the private rented sector, about potentially, you know, NGO-run hostels and other services for homeless people. And they should be trying to prevent your homelessness if they can. But, you know, it's not a guarantee that you'll necessarily get a roof over your head. But if you think that what the local authority are offering in terms of advice is inadequate, it's probably a good idea to talk to shelter and try and get some legal advice. I'm going to start sharing again, if that's okay, just because we've got the rest of the slides to get through. Okay, we got as far as looking at the Housing Rights Information website. What I would say is just please bookmark that and use it, because it's where all the information is. But one of the groups I was teaching, in fact, in Dudley in the West Midlands, somebody in the group said, you know, this would be so much better if it was a diagram, and kindly drew me a diagram, and this is it. Now, I mean, I can take you through it, just so you know, it's just to be sure about the process, but obviously all of the detail you'll need to find from the website, from looking at the regulation, things like that. But essentially you can see that you start off in terms of eligibility saying, is this person subject or not subject to immigration control? If they're subject to immigration controls, the answer yes, you're subject to immigration control because you're somebody who needs permission to enter or remain in the UK. Could be refugee status, could be indefinite leave, could be limited leave, whatever. Then the next question is, are you in an eligible class? If you are, you're in. If you're not, you're not. That's very easy. For people who are not subject to immigration control, there are really two groups of people here. One is the group that the immigration folk here will say, yeah, those are the people who are not subject to immigration control. It's UK and Irish citizens, small groups of people who are exempt from immigration control, members of the armed forces, diplomats, that kind of thing. People with right to abode, don't worry too much about them. And generally, what you'll find there is that you then need to ask the next question, which is this person exempt from the habitual residence test? If they're exempt from the habitual residence test because they've been deported or because they've been part of an evacuation process, then they're eligible. If they're not exempt from the habitual residence test, they need to pass it. And if they pass it, they're eligible. If they don't pass it, they won't. Okay. The guidance on habitual residence says when somebody has been here for 2 years or more, you know, you really need to have a very light touch look at habitual residence. But people could be habitually resident a lot earlier than that, even from day one in some circumstances. The other group of people are those people covered by the EU withdrawal arrangements. So those are people who've got either either pre-settled status, or they've got a certificate of application because the Home Office hasn't made their minds up yet. And for them, they need to know, do they have a qualifying right to reside? Okay, if they don't, they're out. If they do, then you go back into the process and say, are you exempt from the habitual residence test? Because if you're a worker or a self-employed person or a family member of them, then you will be. You're fine. If you're not exempt, then you have to pass it in order to be eligible. So that's a diagram. I'm just hoping you keep it. And then When you get a case, it's just easier to sometimes, some people prefer diagrams, some people like lists of things, are all there. So that is the council. So assuming that you're not going to go to the council for whatever reason, you know, maybe you're eligible, but you're not going to be in priority need, or you might need to find your own accommodation for some reason, then essentially you might then need to go to the private rented sector. And for the private rented sector, we've got a much more recent set of legislation, came along 20 years later, very much as part of the development of all of the hostile environment, along with all, after restrictions on employment, but as a way of bringing private landlords into the network of immigration control. So it covers private landlords and housing associations who are renting directly as opposed to through local authority arrangements. It was all rolled out initially in February 2016. And what it said was it covers all adult occupants of new tenancies created in England from that date. Scotland, Wales, Northern Ireland do not have the right to rent process. So anybody can rent in the private rented sector in those institutions. But in England, you have to be able to pass the right to rent test, and landlords need to implement it in order to stay on the right side of the law. Okay, it doesn't cover local authority referrals, doesn't cover home office accommodation, and it doesn't generally cover most charitable hostels or women's refuges, and it doesn't cover mobile homes, caravans either. And the deal is that landlords need to see your documents, and they need to see the people the documents are about. They need to see all the adults who are moving into the home, not just the people signing the tenancy, but if they've got anybody else living with them, they also need to see them and see their documents. And if there are young people who might be adults, they're not sure, then they need to see evidence of their age in order to decide whether or not they want to see their documents. So for all of those people, they have to see the documents and keep copies and hold on to them for at least a year after the person has left the tenancy. And they need to see these documents in order to work out whether they are relevant nationals, that's UK citizens and people covered by the EU withdrawal agreement. People with relevant nationals technically don't need to prove their right to rent, but of course they've actually got to show their documents in order to prove they are relevant nationals. People who've got indefinite right to rent because they've got settled status, whether that's through the EU scheme or through getting indefinite leave. People who've got a time-limited right to rent, that's people who've got limited leave to remain and pre-settled status, and people who've got a discretionary right to rent. Now, for indefinite right to rent and relevant nationals, that's it. Copy a document, the time-limited right to rent, look at the documents. When does the leave run out or the pre-settled status run out? Landlord has to make a note of that and check again when that date comes round to see if they still have the right to rent, and actually have to also inform the Home Office if the person is no longer has leave. Okay. The discretionary right to rent is to cover people where they don't currently have limited leave, but the Home Office knows about them. So you do get some asylum seekers who arrive, for example, with money, so they're not entitled to asylum support. So they need the discretionary right to rent in order to be able to rent somewhere to live. The end of that year, 2016, they amended the right to rent rules. And what that said was that previously we just regarded it as being an administrative thing. If you didn't get your documents and your copy, then we fined you. Now it's a criminal record. And also, we're going to set up a process where the Home Office can notify landlords that this person no longer has the right to rent, and landlords are then compelled to get rid of those tenants. And that applies not just to all adults who moved in after February 2016, it applies to any tenancy whenever it was started, and it also applies to children as well as adults. Okay, so it's every single tenancy in England. Basically, the landlord could receive a letter from the Home Office saying this person no longer has the right to rent. The landlord then has to serve notice on the tenant, or tell the tenant can go if they want to, but if the tenant doesn't go, they can serve notice on the tenant, show them the document from the Home Office, and then they can either evict them without a court order, so it removes their tenancy rights, or go to court through a particular type of very quick eviction process. Okay. When all this came in, lots of legal cases happened, and the High Court said basically, this causes discrimination. Landlords are choosing not to rent to people who, for example, don't have British passports, and that means that they're discriminating on the grounds of race. This has been through the British courts and is now going to the European Court of Human Rights. The problem with discrimination is if governments can justify it, quote, on the grounds of public policy. In other words, we're doing this in order to try and root out people who don't have the documents that they need and so on, then they can justify discrimination in certain circumstances. The appeal court said, okay, now it's going to the European Court of Human Rights. And the fines were increased last month for landlords, and it's been a massive increase. Look at it. If you are, if you've got a lodger in your home, you just invite someone to come and rent a room in your home, the penalty used to be £80. It's gone up to £5,000. If you are renting privately, not in your home, it was £1,000 and it's gone up to £10,000, multiplied by 10. Okay. And if you've got a repeat breach, you can see it's £10,000 or £20,000. Okay. So it's not obvious why the government has done this. There was a very negative report about the right to rent scheme, yet to demonstrate its worth as a tool to encourage immigration compliance, and fail to coordinate, maximise or measure effectively its use. So, yeah, generally the Inspector for Borders and Immigration thought it wasn't a very helpful or useful scheme. Interestingly, 2022, the fines, they only issued 32 fines on landlords, totaling £29,000 odd. But in 2023, in the first 3 quarters, before all these increases came in, they issued 75 notices and collected £71,000. So they're obviously upping the ante, and they may be hoping to get in a whole load of extra money on that. It still will nowhere near cover the costs of the scheme in terms of the Home Office implementation costs. And of course, it won't go anywhere near the ridiculous costs that the Home Office incurs on all sorts of things. I'm not checking the chat, by the way, so if there's anything in there that I should be responding to, please do say. I just wanted to whiz through some helpful things, I think, that you might find in challenging and using issues around housing eligibility. The first of those is that every local authority and anybody on contract to a local authority is subject to what's called the public sector equality duty. And that means they have a duty to eliminate unlawful discrimination, harassment and victimisation. And they have to advance equality of opportunity between people who share a protected characteristic and people who don't. And race is a protected characteristic. And race covers nationality. And immigration status is often a proxy for nationality. In other words, it's mostly immigration status is covered by all the rules around race discrimination. So, for example, excuse me, if you are, if you're a local authority offering advice to people, as you must do, who are threatened with homelessness, then you must make sure that those people have equal access to it. That people who have, who have a particular immigration status get the same access to the advice that you're providing as other people who don't have that immigration status or don't have that protected characteristic of race or whatever. So that means you have to be able to offer languages and interpreting and translating, and you have to be able to offer effective access, and the advice has to be appropriate. It's no use saying, oh, well, you can apply as homeless when people are not eligible for that service. Second useful thing, all the stuff about homelessness, okay? The duty to homeless people is not triggered by proof. It's triggered by having a reason to believe that somebody is eligible, homeless, and in priority need. So if somebody turns up and says, here I am, I've been thrown out of my home, I have indefinite leave to remain, and I'm pregnant, then the local authority has to say, do I have reason to believe that these things are true? In order to then put a roof over your head and give you the time to provide the proof. Okay, so there's no specified form of ID. It's not like with benefits where sometimes, you know, you can't apply for certain benefits unless you can produce certain documents. The local authority needs reason to believe, and then it needs proof. So, for example, with Windrush cases, of which there were lots where local authorities failed completely in their duties, the local authority should have had reason to believe that these perfectly believable people who had lived here for decades and who had arrived before 1973 and so had indefinite leave to remain were indeed homeless and eligible and potentially in priority need because of their age. But they insisted on getting proof, which of course was not available because the Home Office was not providing it, and that was not legal. So basically, if you've got somebody who is homeless and they believe, and you believe that they are somebody who is eligible, they fit into an eligible class, it doesn't matter if you don't have the documents. The local authority should just have reason to believe them. And to be honest, there's no reason not to believe them unless there's a whole kind of backstory there where they've told different stories to different authorities or something like that. Okay, proof is not needed. The same with saying, and I'm pregnant. I mean, you know, if somebody says they're pregnant, there's no reason not to believe them. They can go off and get medical confirmation of the pregnancy later, but put a roof over their head and know if that's what they need. Okay, so they have a duty to assist people, first of all, to, you know, to deal with them and to give them emergency accommodation if they need it, and also to help them find the documents they need. So where people, for example, have lost their documents or need to get copies of things and so on, they have a duty to do that. And of course, one of the ways of finding out whether somebody is eligible is contacting the Home Office. But there is a code of guidance in force for housing services that says, if the applicant says don't contact the Home Office, then don't. So people need to be sort of quite strong about this if they're going to the local authority, because they don't want the Home Office to be contacted. They need to say, no, I don't want that. The local authority can then say, well, either you give us the proof you say you've got, or find it for, you know, with our help, or else you have to withdraw your application. But it should reduce the possibility that people get reported, if you like, to the Home Office. Okay. Next thing to note is, if you've got somebody who has got this far, gone to the council for help, and they're vulnerable, they have children, they should be referred, but they're not eligible. They should be referred to social services if they're homeless, as long as they consent to that referral. And, you know, and then social services should pick up the duty to accommodate a family with children. They may, I mean, they may only do that briefly whilst other things are sorted out. They may threaten also to pay the fair home, and there's law around that and so on. But there shouldn't be a situation where families with children are homeless on the streets. Okay. Secondly, if you're in accommodation already, you were eligible when things started, but you lose your eligibility, your leave runs out and you forget to renew it, you're somebody with pre-settled status who loses your relevant right to reside, something like that, you know, you get sacked from your job, for example, then you get reasonable notice to leave that accommodation. You don't just get thrown out. And that should be at least a month and possibly longer, depending on your circumstances. And if you consent, then you can also get a referral to social services for help if that's what you're going to be needing. Okay. Lastly, once you've gone through the homelessness process or the allocations process and you've got a tenancy, then it's your tenancy. And if you lose your eligibility later because your circumstances change, because you don't get a renewal of your leave, because you lose your right to reside, you still have those tenancy rights. Apart from the extremely unlikely event of the Home Office sending a letter to your landlord saying this person no longer has the right to rent if you're in a private tenancy. Okay. Another useful thing to know is there will be odd situations where somebody is eligible, but they have no access to benefits, and so they can't pay the rent. It's going to be unusual because mostly housing and benefits rules on eligibility are aligned. But we've had it recently with people being thrown out of the hotels, where of course you've got a gap between being able to, you know, get your universal credit and so on, and sometimes you've got no documentation. in those situations, if local authorities are providing emergency accommodation, it should be at a peppercorn rent. And I do find that, in other words, nothing at all, or pennies or pounds or whatever. So local authorities should be prepared to provide free accommodation in some situations. Where I found this has been particularly useful to argue has been with European migrants, where sometimes the local authority says, oh, you've lost your right to reside, but they're wrong. The person has not actually lost their right to reside. They've got some other right to reside, but it takes a while to sort it out. And in that situation, the accommodation should be provided effectively free of charge if necessary. Lastly, on council housing services in particular, I think it's something else I'm going to come on to on new law that we're looking at. For council housing services, human rights are important. We have actually signed up to the Human Rights Act, and that counts even for people who are non-priority and ineligible in emergencies and other circumstances. So when there is an emergency, we've lived through an emergency with the pandemic, and that created quite a lot of important case law. And there's one here, which I'm sure I've done the date wrong. It's 22, not 2012. I'm very sorry, that's a misprint. But basically, local authorities can use powers that they have to accommodate people who are not eligible in an emergency in order to avoid breaches of human rights, which would be their right to life, their right to rights against inhuman and degrading treatment, or also to avoid danger to public health. Okay, so during the pandemic, everybody was in. Everybody got accommodation, whether they were eligible or not, whether they're priority or not. Okay, and local authorities have the powers to do that. Now, a pandemic is one thing, but you can have localized emergencies, floods, fires, that kind of thing. And local authorities have the powers, and you can argue for them to use it, to accommodate people in that situation to avoid a breach of human rights. So if somebody, for example, has been injured in a fire, then the other tenants all are eligible, but one person isn't. There's no reason at all for the local authority not to provide accommodation in an emergency like that. And this is another thing that's good to know, because you need to watch out for it. Okay, this is a benefits case that's been important for people with pre-settled status. So these are European migrants who have not yet got settled status, who've applied for it but been given pre-settled status. The case, it's a benefits case, was a lady who had fled domestic abuse with a small child and went to apply for universal credit, and she was a cohabitee, so she had no rights as a family member of her ex-partner. She was unable to work because she had a small child, and also generally we assume that people fleeing situations of domestic abuse shouldn't have to work immediately. And she had no other support. For some reason, social services hadn't supported it, and so that wasn't taken into it, supported her. So basically, this case has already gone now to the appeal court, I think, and we're out of the DWP being able to appeal against it or anything. And what the judges have said in this case is that in some situations, somebody should not find themselves in a situation of extreme poverty that does not allow that person to meet his or her most basic needs, such as a place to live, food, clothing, and personal hygiene, that would put them into a state of degradation incompatible with human dignity. It only covers people with pre-settled status because they're covered by the EU withdrawal agreement. And the withdrawal agreement, the first clause in it says we adhere to the European Convention on Fundamental Rights, and and that says human dignity is inviolable; it must be respected and protected. So that particular group of people should be able to get universal credit, even though they're not technically eligible for it because they don't have a right to reside. But the point is that it will almost certainly apply to homelessness services, and there are cases being taken by solicitors at the moment in order to prove that, but we're pretty sure on the law on that. Okay. Last thing, just to note, and I've mentioned this already, we're entering a pre-election period. Things are going to get very, very nasty, and we know that migrants and housing are very much the eye of the storm as far as some people trying to stir up all sorts of problems in order to gain votes are concerned. We've just finished a housing allocations consultation, which is about people who can go onto the housing register. The consultation proposes, the government is proposing that what they want to do is to change the allocation system and to do that in order to set up. Sorry, just my phone going weird there. Thought I had it turned off. So basically, the introduction of a UK connection test, and the UK connection test would say the only people who can go on the housing waiting list are British citizens, Irish citizens, people with a right of abode, European citizens with particular rights protected because of the agreements, people who have recourse to public funds and have been lawfully resident in the UK for 10 years. That will, for example, cover people with refugee status who may have indefinite leave after 5 years. Some refugees will be covered, but it's people who arrived on the safe and legal resettlement or relocation schemes. So Afghans, Ukrainians, community resettlement schemes. We think it's a pre-election manoeuvre. We don't think they've got time to pass legislation or anything like that. But it does mean that local authorities are going to, I mean, most local authorities have responded by saying, we don't want this. But it is an indication of the fact that the government's going to be pushing hard on housing of migrants. And that's just the climate in which we're going to be operating over the next few months. And we need to worry about it. Consultation period is finished already. As I said, many local authorities and all the major housing organisations have said, this is absolute nonsense. We don't want it because it just creates more problems for everybody and doesn't actually sort of solve any actual problems, which is we don't have enough affordable, accessible housing. I've got a little bit longer. I was just trying to find my phone. Yes, I've got 10, 15 minutes or so. Thank you very much for listening and participating. I've got time for questions and so on. Just, you'll get this in the slides, but you've got the website. If you have any contact with local councillors, I really would encourage them to join the Migrant Champions Network, which is a network of councillors who will champion the rights of migrants in their area. And they get all sorts of briefings. I write some of them and work with them and so on it, because I used to be a councillor, just to encourage people to promote their rights and to ensure that migrants are, get equal services and all the services they need within communities. Do talk to us, migration work, about consultancy, research and training, which we do. And if you want to get your local authority to do training on eligibility, I'm always happy to see if I can do that. If you want training on eligibility for community-based organisations that don't have a budget, equally happy to do that. That's my email address, sue.lukes@migrationwork.org, and I'd love to hear from you. I'm going to stop the sharing now and just sort of get to look at people again, which is nice. Has anybody got any further questions or thoughts or wants to ask? I mean, don't have to stick with what I've said, but any other things, or you want me to go over anything again? I have time to do that too.
Hi, Sue.
Hi.
Hi. I
Sorry,
could have a question possibly, but I don't know if it has like an easy answer because it's the ongoing issue with the shortage of accommodations from the local authority. So of course the area where we work is more around like considering the people around their vulnerability. So in some trainings that I have around this matter, the advice has been always sort of like finding a solicitor, a housing solicitor, and challenge the decision. But I don't know if there is any evidence or any sort of like a strategic that it can be as well effective, sort of like pre-action court letters or anything like that that can help to this like negotiation, or well, this will be one question.
Okay, well, starting with that, I mean, the way you challenge housing and homelessness decisions in terms of eligibility is through the county courts. And, it's a fairly sort of straightforward process. Yes, of course, you do need a solicitor. But I mean, I do think that once you sort of, how can I put it? I mean, I think with Brian, we were saying earlier on, I think if you've done some basic training on this, you'll very often have more knowledge available to you than the housing officer you're dealing with. So I would never discourage people from challenging decisions. There are appeal mechanisms. There should be a review mechanism for the homelessness decision, which you're told about, and equally with the allocations decision, there should be a review mechanism which you're told about. And I would always encourage people to use them as thoroughly as possible. And like I said, particularly with vulnerability, because I don't want to sort of, be disparaging of local authority officers, but I think they're under pressure. They're under pressure in terms of the people they can and can't accommodate and so on. And essentially, they very often just sort of look at it and tick a couple of boxes and say, nah, not vulnerable. You're not this, you're not that, you're not vulnerable. But vulnerability is a much more complex issue than that. And I think if you sit down with the applicant and sit down with all the evidence you've got or could get about the reasons why that person is less able to get or keep accommodation than, I think the housing case law said, the average man in the street, whatever that is, then I think you can argue your case. And there's no reason, not to, because you don't lose anything by asking for a review. Somebody put in the chat, are there any cases challenging vulnerability? There are loads of cases challenging vulnerability. This is the legal textbook on housing and homelessness and so on. I knew I'd never be able to sort of get through it or whatever, but there's a whole massive chapter on all the case law and so on vulnerability, and there are lots of ins and outs on it. On the hotels eviction, on the website, we put a briefing about that, because there's a very specific case, because I was involved with it in 1996, which was about a situation where people were deprived of benefits, but still were eligible for housing. And we said, okay, well, that makes you vulnerable then. If you can't get access to benefits, these were asylum seekers, so they weren't allowed to work either. And at that stage, they were still eligible for housing. They're not anymore, of course. Then we said, okay, can't work, can't access benefits, must be vulnerable. How else are you going to access housing if you can't pay for it? So that was the legal decision. So, but that's another factor in it. So access to resources, access to language, the ability to argue or whatever, and if you like, the general problems that you would face if you were physically homeless on the streets are all factors. And vulnerability isn't one or the other, it's all of those things. So I would encourage people always to challenge if they can. And very often when you challenge, what you get back is one of these rubbishy medical reports from people saying, from these private firms of doctors who are contracted in, and the courts take a dim view of those reports generally. There's been lots and lots of examples of them being rejected. Someone said, are they good practice in councils? Yes, I mean, it's lots of good practice. I think the response to the hotel evictions, I mean, I live in Islington, the borough I used to be a councillor in, and we did a lot. I mean, we were giving people a grant of £200 when they got their refugee status in the borough, and we gave them lots of good advice. And set up quite sort of dedicated systems for ensuring that they got the advice they needed when it was needed. Innovative solutions in terms of providing housing, much more difficult, especially in London. There are some, there are very few, certainly in the UK. I did write something for the Council of Europe, but the stuff that we looked at there, a lot of which was wonderful, was all outside the UK, I think. It was sort of lots of interesting ways of providing housing for all sorts of different situations of refugees and migrants. But you've got my email, come back to me if you want to narrow it down a bit about what sort of good practice you're interested in.
Yeah, I had a second question regarding a training that I did recently and I didn't have opportunity to implement at the moment. It's about, sorry, I'm just trying to find it. It was about the housing plans. Like basically when a local authority recognize some duty for a person and is going to do some advice about around housing for the person, how to negotiate, like with maybe this fight about like recognition about like duty to housing then or not, how to go on about, I guess that is like we will be falling again about challenging the decision and discussing around vulnerabilities or what support the people is entitled to, no?
Okay, so essentially the homelessness process is meant to be that you assess them And then you say, okay, so we want to prevent your homelessness, or if not, then we want to relieve it if we have a legal duty to do that. And then at that point, you sort of end up with a plan, and that's what you're talking about. So somebody goes to the local authority and says, oh, I'm going to be homeless, or I am homeless. And the local authority assesses you and says, okay, well, you're eligible, but you're not really priority need because you're not vulnerable enough or whatever, but we're going to give you a plan to help relieve your homelessness. And the plan is very often, here's a list of local landlords, give them a whirl. You know, it's that kind. But actually a plan should be something that is implementable. So it's always worth going through it and saying, hang on a minute, is this a plan that this person can actually do? Because if this person can't communicate in English, has difficulties with literacy, is terrified of approaching new people because of the situation of their experiences or whatever, giving them a list of landlords, and maybe if you're lucky, a pencil and a piece of paper and an access to a phone, is not a plan. So the plan has to be, you know, it's meant to be an individualized housing plan. In practice, a lot of local authorities cut an awful lot of corners on that. And we haven't had sort of much experience of challenging them, but I think it is worth doing that. And I mean, you know, that is a homelessness decision, so you can challenge the decision that the plan is not adequate. I'm afraid I'm always in favour of challenging because I think it makes services so much better. And also because I'm essentially quite optimistic, and I think that very often, because local authority services are so little subject to challenge, most people just shrug their shoulders and walk away. I do think that when they do get challenges, it does mean that they're able to look at the processes and think again. And very often that does mean you get a positive decision out of them. Okay, I think we're almost on time and nobody's waving electronically or otherwise.
Right on time, actually.
Okay, good. Please, please, please look at the slides. Please email me if there's anything in the slides that you want expanded on or references that you want or anything. I'm very happy to respond. It's not, as I always say, a blue light service. You know, it may take a day or two, but I will get there. And if I don't get there, come back to me and remind me again, because I will do my best to get back to you. And it's always interesting to know what's going on in there and what might be possible. So thanks very much indeed. And I may see you at some of the other talks because I think I'm going to sit in on some of them. There's a really good one from Positive Action in Housing in Scotland, quite a lot later on in the session. I can't remember when, I think it's May, which looks particularly at housing for people coming out of hotels and issues around that. So do turn up to that. And Brian may want to encourage you to come to others as well. I don't know.
Yeah, no, there's lots of great ones. I've posted the link on the chat. But yeah, feel free to sign up to as many as possible and please help share in your network. But yeah, thanks so much, Sue. That was really, really informative and helpful.